He told me I had no jurisdiction, left the courtroom, and then amazingly leave the building.
I can't stand. I'm shackled like a criminal over a traffic citation.
No, you're not here on a traffic citation. You're here on contempt. Are
we having a contempt hearing, Your Honor?
Well, I'm going to give you that opportunity. I'm going to advise you if you'd like it. Let me start by reading the relevant portions of the contempt rule, Mr. Forenza. This is Rule 407. This is of the rules of civil procedure, but that same rule applies to criminal actions such as this one. I'll read the relevant sections.
Now, this moment is actually very important legally. The judge is carefully reading the contempt rule into the record. That might sound slow or procedural, but it's actually a protection for the defendant. By doing this, the judge is creating a clear legal record explaining why the court believes contempt occurred. In other words, if this decision is ever appealed, the appellate court can see exactly what rule was applied and why. Courts are very careful about contempt because it allows a judge to impose jail time based on behavior inside the courtroom. So every step has to be documented.
That no warning is necessary or that has been repeated despite the court's warning to desist. Subsection 4 defines punitive sanctions for contempt, which includes punishment by an unconditional fine, fixed sentence of imprisonment, or both, for a conduct that is found to be offensive to the authority and dignity of the court. Most notably is subsection B, as in boy, which says addresses direct contempt proceedings. When a direct contempt is committed, it may be punished summarily. In such case, an order shall be made on the record in writing reciting the facts constituting that contempt, including a description of the person's conduct, a finding that the conduct was so extreme as that no warning was necessary, or the person's conduct was repeated after the court's warning to desist, and a finding that the conduct is offensive to the authority and dignity of the court. Prior to the imposition of sanctions, the person shall have the right to make a statement of mitigation. Mr. Forenza, I'm going to offer you that opportunity in a little bit. I make a specific finding that all conduct that I'm referencing occurred in my presence and therefore is direct contempt. Very specifically, let me make some reference. Mr. Forenza has been disrespectful to the court, to opposing counsel, and even to my clerks throughout the proceeding. He's filed spurious documents. He's made nonsensical arguments. He's been argumentative with the court. But I was willing to let all of that go so we could try the matter. On the day of trial, which I believe was November 24th, Mr. Forenza appeared on time, but stayed in the gallery along with who I believe is his wife. I repeatedly, at least 3 times, but perhaps 4 or 5, told him to approach the court, to cross the bar and sit at table so we could address the trial. Mr. Forenza failed to do so in my direct presence. He told me I had no jurisdiction, left the courtroom, and then amazingly was able to leave the building as well. In any event, he has not returned since November 24th, other than a few pleadings that I'm guessing were filed that day or the day before. I've had no interaction with this case since November 24th. I make a finding that Mr. Forenza was under an order to perform, that is to come to the table. He refused to perform in accordance with that order. And even though he had the ability to perform, obviously he was mobile, he was able to make it into the courtroom and then, of course, make it out. He was repeatedly warned, and I note that I gave him multiple opportunities to approach, and he disregarded all of them. I make a specific finding that I find Mr. Forenza's conduct to be offensive to the authority and dignity of the court. I make a specific finding that he engaged in misbehavior that rises to the level of obstruction of justice. The behavior happened in my presence. The conduct was intentional and willful, and these actions seriously affronted and disrupted the administration of justice. In that regard, I will note that I went and met with the 30 or so jurors who had appeared for the trial, that Mr. Forenza simply blew off. I had to explain why that happened, and I had to waste all of their time. I also wasted the time of the witnesses. Mr. Forenza, I didn't waste anybody. Mr. Forenza also wasted the time not only of the jurors, but of the witnesses, counsel, the court, and everyone else. The court finds him in direct contempt. I made a similar record on the morning of trial. but Mr. Forenza had bolted from the courtroom, and therefore I find he was not advised at that time, so at least not in any significant way. And I hereby advise him. I am considering a jail term for the contempt unrelated to the underlying charges, Mr. Forenza. I'm going to offer you some opportunities of how you want to proceed. First, if you wish, you can make the statement of mitigation right now, if you wish to. If you do not wish to, if you wish to consult with counsel, I will give you time to hire your own counsel, but you will remain in custody during the interim. I would even be open to the appointment of counsel if you believe you are indigent. In fact, I would appoint counsel if you were indigent. How would you like to proceed? And if you'd like a few moments to think about that, I'm fine with that.
Is that the only option is how I like to proceed, or can I make a statement?
Right. So I'm offering you option one and options 2 and 2A. Option 2A and 2B. Option 1 is you can make your statement of mitigation right now, right? And without counsel, the only person in the room other than court staff and the deputy is Mr. McCall. We are live streaming. You can make that. If you'd prefer, you can contact an attorney, and I will set this over for a time where you can make the argument through an attorney. Or appoint, that's 2A. And then 2B, if you believe you're indigent, I will appoint counsel.
Could you explain indigent? I'm sorry.
You meet the guidelines, you're in custody. And so I can appoint alternate defense counsel to represent you in the contempt proceeding if you are indigent. The actual language is in a Supreme Court guidance, which says Colorado, I'll just read it to you. Colorado Rules of Civil Procedure 107 and 407 provide for the appointment of counsel to an indigent person cited for contempt where a jail sentence is contemplated. I am contemplating a jail sentence, Mr. Forenza. If the court appoints private counsel to prosecute a contempt action, which is not applicable here, or to represent an indigent party for contempt charges, that is relevant here, the judicial department will pay for counsel, as there is no statutory authority for the public defender or alternate defense counsel to represent clients for the sole purpose of contempt. But to qualify, you would have to be indigent, which means you would fit below the guidelines for public defender representation. If you wish, I can print those guidelines out for you.
Don't want to be represented.
I'm sorry, I couldn't hear.
I don't want to be represented.
Okay, and you understand that, and I will allow you to make the statement of mitigation right now, but you understand you do have a right to counsel.
The only way I look at it is I never got a fair trial walking into this. He failed to prove jurisdiction, sworn affidavit. The courts failed, personal, subject, territorial. I moved it to federal. I even had documents, which I sent. It was ignored. Everything gets ignored. I'm just, I guess I'll just let you beat me up, throw me in jail, get it over with, because you can't keep me the rest of my life. And then, I'll deal with the consequences and things later. I mean, that's where I'm at.
Okay.
It's not right over a traffic citation where all I did is I came here in good faith to resolve the matter. And it was just, I could get nothing. There's no nature and cause of there. There's no sworn affidavit for me to even move forward on. This court can't move forward on. That's all I asked for. And it was like retaliatory. I just got beat up. That's all this is. It's a traffic citation. It's not a crime. Nobody was injured. If that's, if that's what you call justice and fair, I'm not here to sit here and pick at anybody, go after. That's not what it's about. When I posted bond for whatever it was, I came here and I didn't run. I came here to settle the matter. And that's all I wanted to do. And I just wanted a fair trial. That's it. But you get in my shoes, and how does it feel when you're just getting beat up and the judge you feel is being biased in the case? I mean, what do we?
What else, Mr. Forenza?
Nothing else.
Mr. McCall, I should have asked you this before I moved to me. Is there anything that people want to say on this?
Your Honor, the people spent a good amount of time preparing for this trial. We actually brought the officer from across the state, met with him on the weekend beforehand to prepare for the trial. Officer Carnes was kindly enough, like I said, to drive on his own accord and his own expense to be here. He said he would come back for a retrial. He would he would request to be flown back. Just given the type of the weather that it would be probably when we're done. The people are still open to a plea agreement in this case for the traffic citations. We understand Mr. Forenza's stance as a sovereign citizen of what law he feels applies, but Your Honor, we believe that the traffic laws of Colorado apply in this case. We are more than willing to negotiate a plea agreement to this day. But at this point, Your Honor, that's where the people are, Your Honor. We didn't anticipate any jail in this case. We didn't anticipate anything but to paying the penalties for speeding 25 to 39 over on the Riverside Parkway back in 2023. And the failure license. Your Honor, the speeding ticket, I would even reduce it to 20 to 24 over to keep it in it as a traffic infraction.
On the contempt.
On the contempt, Your Honor. Your Honor, it's been an interesting case for me. I've never had a case that have gone this long with kind of like the lack of being able to move forward. I've never been personally federally attempted to be sued in any case based upon a fee schedule. It finds it interesting that Mr. Forenza believes that contract law applies in this case, but only one way, his contract law. The issue here, Your Honor, on contempt, the people expended a lot of time on this case for a very minor case. I do not like putting someone in jail in this situation. I just don't know if Mr. Forenza will ever show up to a trial again in this case, for this case, or any case. He's done, a day or so in jail.
I'm not, anything else you want to say?
No, Your Honor. The people are, that's all the people are going to say.
Mr. Forenza, I meant to ask Mr. McCall to make that statement before your statement. I forgot. If you'd like to make a statement to address anything he said, I'm happy to hear more.
Yes, I mean, I just object. I did, like I said, I came in good faith to settle the matter. And I tried. So it's not like I'm going to skip down to that. That's not what it was. Because if I did that, I would skip down. Now, I didn't do that. I came here to put the court on notice, let them know I was in federal jurisdiction. That's what I did. And I stood my ground for that. I have rights, and it's not about my contract. That's not what it is. And him for saying it's contract, and that makes it a commercial matter. So I'm here to settle the matter, set off and discharge. And as a secured party creditor, I have a right to do that. An attorney, in fact, representing the estate. So I would like to do that. Let's settle the matter. Let's just wash.
I'll give you an opportunity to resolve the matter, but we're talking about the contempt right now. I view the contempt as your direct and unequivocal disregard of the court's order. What would you like to say in mitigation of that?
Your Honor, it's not. Like I said before, it has nothing to do with that. I wanted to settle the matter, and I feel like I'm running in circles, nowhere to turn. But who do I have to turn to? I'm trying to get this resolved. Coming into court and hoping in good faith that you do the right thing, and it just didn't seem like it was going that way. I've never gotten any response to anything I've ever submitted, and that's what makes it hard. So, how do you react to that? I mean, what do you do? Me, my situation, I'm scared. Okay, well, I have, torture cuffs and sitting here over a traffic citation. Missed my daughter's birthday yesterday.
Anything else, Mr.
No.
Forenza? Okay. Court finds the underlying offense can be resolved. As Mr. McCall points out, these cases are frequently resolved on the first appearance for a fine and be done. I find that Mr. Forenza, I don't know about negotiations. That's not my area. But I find he has not litigated this in good faith. I find that he absolutely and unequivocally disregarded a repeated order of the court to come to the table on the morning of his trial. The remedy Mr. Forenza had would be to have the people try to prove their case beyond a reasonable doubt. He absolutely positively refused the court's order, despite repeated statements. It follows up a long history of disrespect from Mr. Forenza towards the court, and more specifically, the entire judicial system. I find there to be no good faith by Mr. Forenza. I am not addressing the underlying case. I do note that there's a new speedy trial date in that case. That new speedy trial date is July 8th, 2026. I thought about rescheduling the trial today, but I'm not going to do that. I'll do that at Mr. Forenza's next appearance. As to the contempt itself, and this is only as to the contempt, I note the difficulty. My plan was coming in to give 30 days jail, given Mr. Forenza's statement of indicating of the difficulty this has caused him. I'll reduce that a little bit, but not much. This case, I hereby sentence.
And here comes the final ruling, and it's a big moment. The judge actually reveals that he originally planned to impose 30 days in jail, but after hearing the defendant's statement, he reduces it slightly to 25 days. This highlights something many people misunderstand about contempt cases. Even when a judge finds someone guilty of contempt, they still have discretion when it comes to the sentence. The judge is basically saying, your behavior disrupted the court and wasted everyone's time, jurors, witnesses, and the court itself. And that's why this went from a simple traffic matter to real jail time.
So noted. I've sentenced you on the contempt, Mr. Forenza. The next issue will be when I see you next time on the 23rd, right, is whether I should release you in custody on bond after the contempt sentence is over. There is a presumption that that you get a personal recognizance bond on a case like this for the underlying case, but that is overcome. And let me read you the language, because this is what you will have to address. I would recommend that you consider counsel. I have recommended that before. You have disregarded me, and that is in so many other things. The specific provision that is of concern to me, again, there's a presumptive personal recognizance bond. The arrested person has no ties to the jurisdiction of the court, reasonably sufficient to assure his or her appearance, and there's a substantial likelihood that he or she will fail to appear for trial if released upon his own personal recognizance. I will address the bond issue if you wish. The people are on notice that I am open to bond, but Mr. Forenza will not be released until the 25 days.
I feel like this is just retaliation more. And this is what I was afraid of at trial, Your Honor.
It's contempt, Mr.
What I was afraid of. But I wasn't in contempt. I showed in good faith.
Okay.
And I didn't disrespect. I spoke the bare minimum just about jurisdiction. So everything you're saying is that's your assumption. That didn't happen. I didn't.
Have a good day, Mr. Forenza.
I have obligations.
Okay, you'll be able to address them upon release. Thank you.
How am I gonna do that here? I have obligations on the outside that I have to do.
Right. You'll be able to address those after your sentence is